This is Dazza Greenwood, and I just want to start with a quick program note that unfortunately this presentation to Washington, D.C. legal hackers was Zoom bombed at various times. And so I've gone ahead and taken the liberty of just re-recording the presentation part. But we've stuck with the kind introduction from Alex, the host of Washington, D.C. Legal Hackers. So with that program note, let's get right into it.
First, I just want to say my name is Alex Light. I am one of the organizers of DC Legal Hackers, which is a legal hackers organization in DC. And, along with my co-hosts, my co-organizers here, Matt Wexler and Andrew Ware, both, law students or lawyers. And I just want to thank everybody for coming, of course, and apologize in advance for not being able to do in person. We look forward to having a lot of great in-person events in DC, and but as it happens, this one is so good that we just had to do it anyway. Without further ado, though, I'm going to turn it over to my old friend Dazza. Take it away.
Thanks so much, Alex. And that's true. We knew each other when Alex was at MITRE, and it's great to see, your trajectory. And I'm so happy that you are now co-organizer of Washington, D.C. Legal Hackers. Legal Hackers, my favorite group. So I am Dazza Greenwood, and here we go. And I am talking today about ChatGPT for Law to Washington, D.C. legal hackers. And thanks to Alex and the co-organizers, people from all around the world, because you've made this available virtually. Legal Hackers is a group that I've enjoyed being a member of and a co-organizer for a chapter of for many years. We are explorers, we're doers, and we invite you to join us. Go to legalhackers.org and find a chapter near you. Now, the first thing I should say is I'm actually changing the name of the advertised talk from ChatGPT for Law to Generative AI for Law. And that is because it turns out ChatGPT, although it has made a huge public splash, is just one example of an emerging class of technologies, which is known more generally as generative AI. Let me start off with what I think will soon be a standard warning, which is that this technology, while it is remarkable, is hardly perfect. In fact, it is prone to sometimes providing false information, as well as, it is prone to sometimes providing false information, inaccurate output. There's a risk of over-relying on it, only to be disappointed when you discover that some of that information might not be correct. And it also has prejudices and biases that seeped in through the training data. In the words of Sam Altman, who heads up the company OpenAI that provides ChatGPT, he says ChatGPT is incredibly limited, but good enough at some things to create a misleading impression of greatness. And it's a mistake to be relying on it for anything important for now. It is a preview of progress. And we have lots of work to do on robustness and truthfulness. So with those sobering disclaimers, let me talk now about, in fact, how awesome this technology is and how much can be done with it and is being done with it now in a legal context. Dan Katz and Michael Bomarito recently have, for example, applied this technology to taking the bar exam. And to my surprise, the current generation of the technology did pretty well on the bar exam. It did not ace every single section of the bar exam, but it did pass in a couple of sections and it did serviceably overall. This is a major improvement, I hasten to add, from what was available not long ago. You can see more about that in a recent presentation that Dan and Michael provided at the MIT Computational Law Workshop, which you can find at law.mit.edu. There's also a bunch of commercial offerings already available. I'm not endorsing any of these, but just by way of example, Ironclad has something called AI Assist. Spellbook also has a contract related generative AI tool that's integrated in Microsoft Word, right, where a lot of lawyers live. And there's plenty of other products as well and services, and a lot more in the pipeline. And academia is beginning to dig in as well. I think there's one paper that is really right on point called Legal Prompting, teaching a language model to think like a lawyer. There's a lot of good stuff in that paper, and there's tons more where that came from. So law firms, in-house legal departments, government lawyers, and others are all trying to figure out what this technology is and whether or how to use it. So here's some ideas and examples to help answer those questions. You can engage with this technology through something called a chain of thought kind of series of prompts. But to sort of get what I'm talking about here, let me back up a little bit and say many people I've noticed when first exposed to this technology, especially through the interface that's a chat interface, where you put an input in, some prompt, and you get some output, are wondering, like, well, what do I ask? And you know, they may ask a kind of a yes/no sort of question, or a question that has a single answer, such as like, what is a contract? That's understandable, but that's not really the best approach to this technology in terms of getting the most out of it. And so I sort of liken that to what I'm told it was like when cars were first introduced. You know, by way of a quick anecdote, my father, when he was young, growing up in Boston, his first job as a youngster was riding along on horse-drawn wagons and delivering blocks of ice to people. And he remembers what it was like when cars were introduced and when they started becoming widely available, and ultimately really were kind of boxed out horses and wagons on the roads of Boston and every other city. And there were questions about exactly, you know, what are they good for? And some people would refer to them as horseless carriages. Well, I mean, there's some truth there, but just as you wouldn't try to put a saddle on a car, similarly, we need to look at this technology differently from what we may have been used to in the past with chatbots. It has a chat interface, but it's a qualitatively different kind of technology. So instead of doing like a single question looking for a single answer, that would be maybe the rough metaphorical equivalent of like hitting the accelerator in a car and it goes 10 feet and you draw the conclusion, well, what is this thing good for? It just goes 10 feet. Rather, the way to approach a car for that metaphor is you use a few controls kind of in combination as part of a process of driving. So you kind of hit the gas, you tap the brakes, you turn the wheel, you're steering it. This is a pretty apt metaphor for chain of thought prompting. So with chain of thought prompting, what we do to engage is we'll put a prompt in, we'll get a response, and then we'll do follow-up questions and follow-up questions, or better yet, follow-up instructions to sort of move it in the direction that we want by steering it and by maybe backing off, sort of like the brakes, some directions or tangents it might be going even more faster in some other directions by directing it with the language and the prompts. So here's one pretty good example that Damien, just pull it up here. Yeah, here's a pretty good example from Damien where he started by taking a motion to dismiss, and his prompt was, below is a table of contents from a motion to dismiss in federal court. Please create a bullet-pointed list of counterarguments. And he inputs in this pretty well-formed table of contents. Gets a pretty good output. Step 2, here's the prompt. From each bullet point above, include sub-bullets for the elements of each claim. Okay, here's the prompt. And then here we go. Lo and behold, it maintains a context from the previous prompt, and you can now do follow-up questions and deepen or steer it in certain directions. And we've got, so for example, for this first one, plaintiffs have standing to assert their claim. Just check up here. Yep, plaintiffs have standing to assert their claim is the first one. And now we have some sub-bullets. They've suffered an injury in fact. The injury is traceable to the defendant's conduct, and so on. And we have those for each point. Step 3, flesh out exemplar facts. So in other words, you can go deeper and deeper. This is a pretty good example of chain of thought prompting. Okay. Yeah, let me just. At this point, I might just also mention that beyond doing a kind of Q&A or directing it in a conversational kind of format, generative AI can also be used in lots of other ways. So it can be part of workflows. You can sort of use APIs to insert it at certain points in a process. For example, it can summarize people that are coming to lawyers and seeking help, for example, at an aid clinic, and can help to surface the key issues and then triage that person to the right kind of department, whether it's like landlord, tenant, or benefits, or someone else that can help them. So these sorts of things can be really helpful. There's been a lot of interesting work in the consumer rights space as well, using this type of technology to help people, get refunds and wrangle over issues with their bill, sometimes with other bots that are there on behalf of companies. I'm getting into a bot versus bot context there. So let me go back now, though, to the main thrust of this talk, which is how to use these technologies and how to make the most out of them in a legal context, and in particular, how to do the kind of prompt engineering that's unique to law, or what I like to call legal prompt engineering. So here's some examples that I put together for that recent MIT workshop that I just mentioned. So the most important thing is to include in the prompt as much of the relevant legal context as possible. So you don't need to write the whole thing, although you could provide a draft and ask it to improve the draft in various ways. But if you, at least in the prompt, say, like if you're looking for depositions, starters for deposition questions, you would include things such as the purpose of the deposition, what the parties involved, what the specific issues and facts are that are in dispute, what sorts of evidence you want to ask about, that sort of thing. And you include that literally in the prompt itself, and the response you'll get by way of potential deposition questions will be much, much better for it. I encourage you to play with this and try to ask the same question a few different ways and see for yourself how more legal context will yield much better results. Here's another example for say you're looking for a first draft of a contract for the sale of a car, maybe a low stakes transaction like the sale of a used car between two individuals. You could just ask for a draft contract for the sale of a used car between individuals in the state of California. You get something back. It'll be pretty good, but not usable yet. But if you were to then sort of fatten up that prompt with a little bit more relevant legal context, you'll get back something a lot closer to a draft that you might want to use. If you include the make and model, the VIN, and so forth, the purchase price, of course, any warranties or representations. You don't have to write the entire warranty and representation out. You could just summarize or just have some bullets of the warranties that you might include or disclaim. The date that it will be delivered, basically the deal points, right? And you include those in a prompt, you will get back a draft contract that supports and reflects that legal context, and it will be structured pretty well, because these things understand the structure of a variety of different types of documents and other instruments. So you can now go a little bit deeper, and you can do some things like you can tell the AI who to favor. You can ask it to provide you a draft that favors the seller or a draft that favors the buyer. And here's some more information on all that. You can also do some even more subtle things. So for example, if you're seeking a strategy for a dispute negotiation, say with another company, if you're in an in-house kind of context or you're working in some sort of corporate context, you could ask for one strategy in the kind of persona or in the style of a celebrated litigator, and you'll get a strategy that probably highlights the type of the type of approach that a litigator would use, which would include certain types of legal pressure, certain kinds of basically threats, and other things like that. You could also ask it to provide the dispute resolution strategy in the style of a celebrated mediator. So maybe this is, for example, in the context of a company that does a lot of business with another company, has a lot of different interactions going, is going to be doing business with them for many years into the future. You might not want to do a hardball negotiation. You might want a fair result with the idea that it will kind of even out over time. And by seeking a draft strategy in the style of a world-renowned mediator, you will get, more like kind of win-win sorts of approaches. There's a lot more detail of those kinds of examples right here in this GitHub repository. I'll come to Claude in a moment. So yeah, and that moment is now. So there are some more examples that I want to show you of this chain of thought style of legal prompt engineering. One of the things I've been working on lately is trying to probe the capabilities of generative AI with respect to fiduciary duties, in particular the fiduciary duties of care and loyalty, to see how well or poorly various models and implementations of generative AI can correctly basically understand and identify these duties and can apply them properly in various contexts. So this first link here goes to a long chain of thought prompt session with ChatGPT. And you can find that right here at civics.com/pub/chatgpt-session-2022-12-17. In this case, what I did was, actually, I'll go back here to the summary. I started by having it basically create a scenario of some dispute over a purported breach of fiduciary duties of care and loyalty. Probed the contours of that a little bit with some prompts you can read all about in that blog post. I then went on to have it basically have this dispute litigated. And I can show you what that looks like right here. well, and part of the probing it, by the way, was great. I asked it, what kind of causes of action might exist, what defenses or counterclaims might the other party have. Lists a few pretty good ones: lack of causation, good faith reliance, counterclaims for breach of contract. This was in a kind of corporate CEO employment context. I go on to explore what kind of evidence would the company seek to admit. It gives me some good ideas of types of evidence: written contracts, corporate records, email communications, expert testimony. Then I go on to say, let's assume the company were to call an expert, like in trial. Give me some of the questions that they would ask. And here we actually have some direct examination of an expert witness on question of whether or not the defendant breached their fiduciary duties. Then I want to ask about cross-examination, the defendant's Bob. And Bob does some pretty good cross-examination here, which is not bad when you're just trying to role play and kind of get a sense of how something might go. Anyway, I do some witness examination and cross-examination in different ways. And then ultimately, that's a good one with a financial advisor. And then ultimately, I ask for a judgment. Oh, I do closing arguments from both sides, which are actually pretty good, I thought. And then I asked, I don't actually tell it which way the judge went because I was curious to see what it would say. So I just say, that's great. Now let's assume the jury verdict has been read and the judge has written an opinion and holding, including determination of law and fact. For this case, please write that judicial opinion. I just want to see how it would decide the case. And it decided, relatively conservatively. You could read all about it right here. And in favor of the company against Bob. So Bob is deemed to have breached fiduciary duties in this case. And oh, here's another thing. Sometimes it just sort of, do you see how this just sort of ends in the middle of the judge's ruling? This opinion is based on the finding of law and done. It just kind of ran out of tokens. So my prompt next was, please continue the judicial opinion starting from, quote, this opinion is based on the finding of law and ... end quote. And look at this, it just picks it right up. Opinion of law and fact made by the court during the trial, et cetera, et cetera. We go right down, see how this is pretty much in the generic form of a judicial ruling. The court also finds damages. In conclusion, the court finds Bob is liable for breach. Not bad. In fact, I say really good. So now let's assume there's an appeal. And I go through a whole appeal. I don't want to kind of go through this whole very long thing. We appeal it right up to the Supreme Court eventually. So ordered. And then I say, please assume a little fewer than half the justices vigorously dissent. Write that opinion. And here we have a vigorous dissent from some of the justices. Now, here's something interesting I do want to dwell on for a moment. I say, now let's assume it's 3 years later after the Supreme Court decision, which was upholding the lower court decision. And I say, let's say that there's been a groundswell of public opinion and political outrage about the decision of the court in this case, and an outcry in favor of the dissenting opinion, which you will recall I had the AI already draft. And so it should be in a kind of active memory, in a sense, in a vector space. Please write a news article covering the rise of this widespread movement in the US over the 3 years since that court ruling. And I get it sketches out what the issues were and what people are upset about in terms of, liability and where we draw the line on these things. And the reason I did that was because I wanted to start warming it up to write some federal legislation, which I do right here. Let's assume bipartisan federal legislation is gaining support to achieve the legal reforms and business policy advocated by this groundswell of public opinion and political outrage. So now, instead of just saying, write the legislation, I again want to warm it up and then have something I can refer to go expand, to accordion out later. So I just say, to start with, please outline the key provisions of that legislation. And here we go. We get some interesting provisions, which I actually thought are pretty on point. So I'm not going to actually break this down substantively, although there is a lot to say about it. So then the very next thing I do is I kind of go for the semantic jugular of this legislation by asking it to give me the definitions section for the legislation. And it creates the words that would be defined and provides their definitions. Notice clear and convincing evidence is here, and that is exactly one of the things that they outline, is that we should change the burden of proof, and some other things are defined. So it kind of obviously has an idea of what the legislation is going to be. We have some defined terms, and so let's get into it. Please write the first substantive section of this legislation. Here we go. Fiduciary duties of care and loyalty, and it sets down what those would be. And then I just say this a few times. Please write the next section of the legislation, protection against baseless lawsuits. Please write the next section. Section 4, support for good faith actions. Write the next section. Section 5, enhanced disclosure requirements, which is something, if you go back and read this, you'll see came up in the litigation. Next section, stronger enforcement mechanisms, and they are pretty strong. The next section, preemption of state law, very typical. Now, I'm not sure if it's done yet. Preemption frequently at the end. So I ask for one more section and I get effective date. Okay, now I'm definitely feeling like we're at the end of that's very frequently at the very end of legislation. So let's assume that it was passed, signed into law. Let's get the signing. At the signing ceremony, let's get a transcript of what the president says. We get a little transcript of what the president says, basically echoing everything that you really speaking to what the groundswell of public support was for with respect to legislative reforms, and spinning this specific legislation, pretty well. I mean, simplified, but hitting the high points. Now we go. This is much more important right here. So now that we have had a dispute over fiduciary duties, it was litigated and appealed, and there was case law. And then there was legislation basically reversing that case law, that Supreme Court case. Now, what I want to do is fundamentally relitigate the same case, but under the new law, and see, do we get a different result? So in this case, the prompt is, now let's assume the same case decided by the lower court was litigated between Bob and the company after this legislation was enacted into law instead of before it was enacted. How would the litigation be different if this law had been in effect and applied to the lawsuit between Bob and the company? And you know what? To my kind of actually shock at this point, it does a pretty good job. And I thought to myself, I kind of traced back the dispute and the points at issue and how it came out vis-a-vis the reform legislation. And it occurred to me that the result may very well be different. It's hard to always know definitively what a result will be, but it seemed to me that there is a reasonable chance it would come out differently, and it hits the very points that I thought it would hit, and it wrote them out pretty well in longhand here. The burden of proof for the company would be higher under this legislation. The company would be required to demonstrate clear and convincing evidence of a breach of Bob's fiduciary duties of care and loyalty in order to bring an action against him. This is a higher standard than the preponderance of evidence standard that is typically applied in civil cases. So that, of course, would make it harder to win. And we have some other things about damages and some defenses that Bob can assert. The company would be required to comply with enhanced disclosure requirements under the legislation. The company would be required to disclose, et cetera, et cetera. This could potentially provide the company with greater transparency and accountability. Oh, this is what I was looking for. This could potentially provide Bob with a stronger defense against the company's allegations. So anyway, it's not a like, first-rate legal analysis, and some of it is a little bit muddled, but it's basically doing some logical legal reasoning against facts, applying law to facts, and then playing with counterfactuals as well, like hypothetical situations. Not bad at all. for extra credit, I just wanted to see, how might this change standard terms of directors and officers liability insurance policy. And we get some things about kind of premiums and scope of coverage and so forth. Oh, and then my last question was, if the investment advisor provided, which the CEO in my hypothetical asked for advice on the investment before doing it, which is what caused all the litigation to start with. So I asked, if the investment advisor provided their advice through an automated chatbot, would it still be reasonable for the officer to rely on that advice? And that's when it timed out. I sort of like blew its gasket at that point, but this was going to be part of a new subsequent chain of thought that was going to get into how reasonable is it to rely upon the output of generative AI style chatbots, but we never got there. Not with Chat GPT, we didn't. But then I did a head-to-head comparison with Anthropics, who's another very interesting generative AI company here in the Bay Area, and their generative AI chatbot product, which is called Claude. So I've got access to Claude, and here is a fundamentally identical, just different in a couple of little ways, replay of that same transcript that I just did, that I just showed you rather, with ChatGPT. So again, I have it come up with a scenario with a breach of fiduciary duties. I had to go back and forth here a little bit before we kind of found the scenario that I liked that was comparable to the scenario with that ChatGPT came up with. And I finally felt good that we had that. And then I basically tried to copy and paste the same prompts that I had used. Now, one thing that's a little bit different is sometimes I had to, because it had the case come out differently, some of these prompts you'll notice talk about Bob instead of the company, or the company instead of Bob, but they're fundamentally parallel lines of chain of thought here. And so let's stay focused on the claims, assume the facts are not disputed. So I want to see, like, what are people going to be arguing here? And something I found really interesting is the answers are a little different. Like Claude was a little bit more subtle, I thought. In some ways it was more creative. I really liked a lot of the answers that ChatGPT gave. They were very tightly structured and frequently more in the form of a finished product. This one was a little bit more, a little higher level, and it was also quite erudite in the sense that toward the end of most of the responses, it would kind of give me a meta-analysis of what the response was. So here's the answer, followed by a little paragraph sort of characterizing the answer. And then, here again is an answer. And then you'll notice it's a sort of a pattern here. Then we have a characterization of the answer, kind of talking things through and sometimes asking me, whether I would want to tweak this or if I want to kind of delve into any specific answer. I pretty much ignored all that for this purpose because I just wanted to plow through a parallel chain of thought set of prompts to see if we could get to the litigation, the appeal, the legislation, and so forth. But as I continue to play with Claude, I'm going to take it up on its interesting offers to go down some of these rabbit holes and see where that leads. But let's just take a look here. Let's see how things are the same and different. Oh yeah, didn't really talk about this in the ChatGPT one. Yeah, so we do the same examination and cross-examination. There's a lot of overlap, but it brings up some different points. And ultimately, when we get to the closing arguments, which were different, of course, they're different every time I run this through ChatGPT as well, but these are different in a different way. They are, again, I think it felt a little bit more creative in some ways. So let's assume the jury verdict has been read. The judge has written the opinion holding, including the determination of law and fact. Please write that judicial opinion. Same question. Here is a possible judicial opinion for this case. Also, I'm not sure why ChatGTP doesn't do that, but this usually Claude usually has a sandwich where it sort of says what it's going to say, it says it, and then at the end, it sort of tells you what it said and kind of gives a little bit of meta conversation about it. So now I go through the appeal to ask what would be good on appeal. We take it all the way up to the Supreme Court. Go through the Q&A. Oh, let me go back up to the top of the legislation. Oh yeah, here we go. It's 3 years later, same exact prompt. There's an outcry, write that news article chronicling 3 years. Now, in this case, it's interesting partly because Claude decided the case the other way around for the other party, but it's pretty similar. And this one's actually got a little bit more sizzle, I think, in terms of the narrative. So I think, Claude has flair, I'll say that. And then look at this at the end. How's that? I aim to capture the major elements of the news, like who, what's involved, blah, blah, blah. Let me know if you'd like me to modify anything. Again, I can't wait to spend more time with Claude and go down some of those side roads. But for this purpose, I just wanted to, again, do a head-to-head test. So I said, let's assume there's federal legislation now. Give me the outline. Here we have the outline. Require officers and directors to act with a duty of loyalty, heighten the duty of care. Interesting. So going deeper into the substantive law as opposed to the burden of proof, establish private rights of action. And then we have some regulatory stuff here, giving SEC enforcement rights. And that ends up being fairly big in terms of the shape of the legislation and the possible legal outcomes as well. Give me definitions, give me definitions. Give me the first substantive section, the second substantive section, duty of care, and so forth. I kind of felt overall that ChatGPT, I just kind of liked its legislative style better. It was crisp. Claude had some really interesting ideas. To be frank, they both are blowing my mind in terms of what they can do. I've written a lot of legislation, federal and state, and the idea that it can do this and so quickly and coherently overall is going to take some getting used to. I really like having this as a capability. This is going to supercharge a lot of my work in the future. But anyway, let me keep going here. This is really good. Write the next section, write the next section. And then one thing I noticed is it kind of starts getting a little sleepy or starts drifting off course toward the end here. So I just say the same exact prompt. Please write the next section if there is one. And then it's kind of saying, instead of just giving me definite sections, it's saying, here's some possible sections. And then it gives me things in legislative terms. And then down here, here's some possible additional sections. ETC, like it's not really writing crisp legislation anymore. It's just kind of, although the content is ridiculously good, especially given it came up within like 2 seconds. So anyway, now we come out to give me a signing ceremony transcript. We get one. Now let's assume the same case was decided under this legislation and it runs through the analysis. It's kind of convex or to the first one, and it does a reasonable job. Ask it about D&O liability. It does a pretty good job talking about premiums and some substantive terms. Now here we go. So it may have got a little sleepy on the legislation, but it's sticking with me in terms of the long chain of thought. So I've not run out of tokens or space or memory or who knows what the limits are exactly. So I go ahead and ask it about the investment advisor, and then say, if the investment advisor provided advice through an automated chatbot, would it still be reasonable for the officer to rely on it? No, it would likely not be reasonable for the corporate officer to rely on investment advice provided by an automated chatbot. While officers can delegate to and rely on experts, that implies human experts and professional judgment. Relying on AI or automated systems that are not professionally developed or overseen to provide material investment advice would likely fail to meet reasonable diligence and due care standards, et cetera, et cetera. Pretty good. I have to say overall, pretty good. So, I mean, there's a lot more interesting things to explore how the models are dealing with this stuff, but there is an example of longer chain of thought examples going through this kind of life cycle merry-go-round, like 4-year life cycle hypothetical situation, and doing that with OpenAI's ChatGPT and Anthropic's Claude. So where does that leave us? So the role of an attorney, I think one way to look at it with respect to these machines is we can look at the inputs and we will look at the outputs. So at input time, lawyers, like everyone else, but in our own way, lawyers, we need to get much better at prompt composition, how to compose a good prompt. One more time, you want to front load that prompt with relevant legal context. Relevance is something we understand as lawyers. Anyone's taken the rules of evidence can start to come up with mental models about what isn't relevant, like who are the parties, what are the interactions, what are their rights and obligations, and then put it into context to know what types of things you want to ask about. I gave some examples in the fiduciary duties, but it's very fact specific. We want to be creative. We want to compose good prompts. We want to then engage with the generative AI through chains of thought prompts. So we want to be able to go several rounds with it to start to kind of unpack the question at hand from various perspectives and different kind of facets of the question. Some other things is at the front end, we can also be looking increasingly at different types of integrations with other applications and services as ways to put some of the input into the prompts. So I mentioned, for example, legal triage. There's infinite other types of examples. And one day we'll want to get even deeper down the stack to things at the kind of prompt plumbing level, such as LangChain. And that's a little more technical than we need to get into right now, but stay tuned. There'll be more on that at law.mit.edu, probably civics.com. So that's the inputs. On the output is also a really helpful place for lawyers. Why is that? Well, do you remember that big disclaimer about false and inaccurate and prejudice and stuff like that? Well, that's a place where we're going to want to do a lot of due diligence. We're going to want to ensure reliability and accuracy and factualness and the legal reasoning and the correct sources are cited. All the same basic stuff that we do today, we will want to do in this context as well. We'll be advantaged in many ways by having the capability to turbocharge generation of some first drafts and some other content, but we're also going to have to apply our same professional skills, in some ways, even in even more of a disciplined way, to avoid the temptation of over-reliance on the output of the machine. Because even if it's great and perfect, 9 times out of 10, we still have to check it just as thoroughly that 10th time. We're not at a place where we can just rely on the stuff from these machines by a wide margin. We cannot rely on the first draft that these things come up with as the last draft. So one of the things I want to be working on through 2023 is what are the methods and mechanisms by which we can apply professional due diligence and how do we provide legal assurance exactly in this context? I think there will be some repeatable kind of processes that can be used in some ways to start to measure things a little bit better. So we'll be getting more into that later in the year. So that's the input, that's the output. What does that leave? Well, the stuff in between. And so I don't expect that lawyers will become data scientists. I don't think that that's really necessary at all, but that doesn't mean complete ignorance is the only other option. I don't think it's the best option. I think becoming somewhat acquainted and familiar with what these models are, kind of what they're good at and what they're not as good at, and what the services are around the models is absolutely something that attorneys should become familiar with. And so just by way of an example that's torn right out of recent headlines, there is a show involving this fictional character known as Larry Feinberg. It's basically a show that's kind of like the Seinfeld television series, except for some of the names are changed and all of the dialogue is generated by Chat GPT, and the voice is generated by AI, and the visuals, like the cartoonish like visuals, are also procedurally generated by AI. And so there's this on Twitch, the video streaming platform, there was this kind of 24/7 Seinfeld-like show that was going. And at one point, due to some technical issue, they decided to swap out the more modern Da Vinci model, which is this model here, that's the same one that powers ChatGPT that's so good, for an earlier model, which was this one, Curie. And so you might think, well, what do I know or care what the model is? But, it turned out that that model had some different capabilities in the moderation system that they had used through an API with OpenAI was not operating on that model. So I'm not I don't have access to the logs. I don't know exactly the details of how much of this, what happened, we can lay at the feet of Curie versus lack of moderation or some combination. But basically it started spewing out this kind of transphobic, homophobic, very problematic dialogue, and Twitch suspended the show. Here's an example of some of the moderation that's available, by the way, through the OpenAI API for moderation. And it kind of does things like looks at like hate, self-harm, sexual stuff, violence, and so forth. And you can use that to filter or to do various things. This has got a kind of a kind of business audience kind of element. It has a technical element. It's part of an API, but wouldn't you agree this also has a legal valence as well? It does. And so really it's part of what we want to be aware of is like, if we're working with a team and their company says, hey, we're switching out Da Vinci 003 for Curie 001, ask things like, will the moderation API still work? And then ask a bunch of questions to try to understand what they're talking about and what's likely to happen, and read up. Start coming to law.mit.edu idea flows when we're going to get much deeper into a lot of this stuff, and get educated now. You don't have to be a data scientist to understand the stuff that I'm showing you right now, and it does matter. So over the horizon is, as I've just mentioned, there's ChatGPT and there's Claude. There's a bunch of stuff. Bing and Microsoft's Bing is about to integrate some of OpenAI's generative AI. A bunch of Microsoft's Office and other services and platforms are going to be integrating this as well. And Google is integrating generative AI in a lot of its services. So are a bunch of big companies and a bunch of small companies. So be on the lookout for the coming plethora of apps and services. Is there a role for attorneys in evaluating them? Question mark. My answer would be yes. Another thing to be on the lookout for, fine-tuning in legal contexts that are fit for purpose, like, for example, for legal purposes, to solve legal use cases of the types that I was just demonstrating earlier in this talk. Fine-tuning is when you take one of these large language models and then you actually add basically something like additional training data. You add in more data. And so I'm not talking at this point about including information in the prompt, but I'm talking about feeding more data in. So I think there is going to be a lot of mileage for domain-specific legal contexts that's available with fine-tuning. More on that later. There's also human reinforcement learning, and one wonders if, and I haven't talked about this, but that's part of the whole architecture and kind of the whole process of what brings these large language models into applied applications like these chat interfaces and some of the other services as well. Part of what makes them work so well is having human reinforcement learning as part of the finalization of the product that they bring to market. And so that involves labeling, and maybe there's opportunities for more legal specific labeling as part of this reinforcement process. Is there? Maybe. Combining with other types of AI. So this generative AI is different from what used to be the type of AI that was frequently talked about for legal contexts, which was based on symbolic logic. That's more like kind of close to pure logic. And that's very good for certain types of declarative kind of process-based reasoning. Some legal things are very much that way. It's got different capabilities, and it sort of solves somewhat different types of challenges, but perhaps combining symbolic logic and planning systems, like Meta has an interesting planning system that knows how to play diplomacy type games and can think several steps in advance and can sort of navigate to a specific end. That's not what's happening with generative AI. That's closer to figuring out what the just what the next steps and are going to be from a somewhat statistical, probabilistic basis. That's different from picking a point on the horizon and navigating toward that point. Maybe some combination of these other types of AI approaches together will come closer to providing even better legal outcomes and results. So these are some things to be looking at in the future. Where we're at now is remarkable, but I really want to emphasize it is just the beginning. So I want to thank you very much for your attention to this talk, and I look forward to engaging with you all. If you'd like to learn more, come to civics.com and just click on the blog where I will post this video and where you can keep up with my blog posts on this topic and related topics. Also, I hope that you will come to law.mit.edu, where you can see our periodic idea flow episodes, where we will engage with some bright lights in this field and unpack some of the important information and some of the important questions that arise. So until then, I look forward to seeing you, and thank you very much.